Welcome, and thank you for coming today to this press conference. I'm joined by, as you see, people in green vests, a small segment of the people involved in this wind noise rule issue. Also with me today are Attorney Stephanie Kaplan, and who will be speaking, Ed Stanek and Noreen Hession of Energize Vermont. The last time I stood before this podium was in February 2016, on the day that the Attorney General's office announced they were closing the criminal investigation of me for allegedly practicing law without a license. That effort was an overreach by the renewable energy industry to try and, as the editor of the Burlington Free Press said to me when he called to say, "We're naming you Vermonter of the Year, you're effective. You're so effective, they tried to shut you down." Last week, we witnessed another overreach, as the editorial writer of the St. Albans Messenger said yesterday in his editorial, by the wind industry in their attempts to influence the work of the Public Utility Commission in their rule development. The wind industry was very obviously attempting to get the rule changed in a way that was entirely inappropriate and exceeding the authority of LCAR. And we witnessed it to such a disturbing extent that on Monday at 1 o'clock, Vermonters for a Clean Environment did something that we have not done in the 18 years that we have been in existence. We filed a Public Records Act request of all 8 members of the Legislative Committee on Administrative Rules. This is something that we did not do lightly and that we take very seriously, asking for all of the correspondence between the wind lobby, their experts, their advocates, the lobbyists, their staff, their board members, and the 8 members of LCAR. That was filed at 1 o'clock on Monday. It's an immediate request. It requires a response within 48 hours. So this press conference is 48 hours after the response was submitted. I think technically they have till the end of today. As of now, Representative Sheldon and Myers have complied and completed their response. Representative Myers had nothing. Representative Sheldon submitted documents that came in while I was driving up here that I haven't read yet. Senator Benning responded immediately with a partial response, saying he had reviewed his personal emails and he doesn't have anything and he would be back with his legislative emails. Additionally, we've heard via Legislative Counsel that Senator Lyons, Representative Yantachka, and Representative Chestnut Tanderman are taking the legally allowed 10 days to respond, and they will try to get us their responses by October 30th. We have had no response yet from Senator Sorokin or Senator McDonald, the chair. We have taken this extreme action because of what we witnessed last Thursday in this 4-hour hearing that did not break for lunch, where LCAR attempted to open up the rule and engage in technical issues that are entirely inappropriate. If LCAR was going to reopen the rule to make changes, we have changes that we want too, yet we saw no concern to address the numerous deficiencies that we outlined in our June testimony. We have not been lobbying LCAR to please open up the rule. We testified in June that the rule met legislative intent with the setbacks. We testified again in June that the rule did not meet legislative intent without the setbacks. The most egregious deficiency in this rule is the failure to regulate low-frequency noise, and that's something that New York State does. There are many other issues, such as the lack of a property boundary standard, which the state of New York regulates. Vermont's rule doesn't apply to seasonal residences. New York does. These are not anti-wind things that we're asking for. We're asking for protections. But we were willing to accept the process that the PUC went through was professional, they did their job, and to watch LCAR's members whittle away at the rule was just so egregious. So we decided it's time for sunshine so that Vermonters can understand the role that the wind industry is playing in influencing our legislators. And I'm going to turn now to Ed Stanek, who was in the room and will speak from his experience.
I'm Ed Stanek in Barre City. By way of introduction, I was employed for 30 years as a district coordinator for the Act 250 program. I also served for 6 years as the president of the Vermont State Employees Association, and in other capacities, since I retired, I've been helping Vermonters before the Agency of Natural Resources. My activism includes, dating back to the 1970s, efforts to close Vermont Yankee, and I was also the Progressive Party candidate for Attorney General in 2012. I mention all this not to toot my horn, but simply to indicate frequent attendance over those 3 decades at the hearings of the Legislative Committee Administrative Rules. What I witnessed on October 12th by the Legislative Committee Administrative Rules was a shocking abuse of process. The committee indicated a blatant disregard for a fundamental principle, and that is the presumptive competency of an administrative entity, such as the Public Utilities Commission. The Public Utilities Commission undertook a rigorous public process for months, going through Vermont, conducting workshops, getting input from the public, including some of the experts who testified before LCAR, taking the second bite at the apple. What happened at LCAR in its motion to object to the sound setback standard was not only a shocking abuse of process, but a shameful day for democracy in Vermont. As you can see, the folks here today represent a very broad coalition of Vermonters across the political spectrum. I dare say this may be the most broad coalition ever in the history of Vermont. We are united in and standing shoulder to shoulder in our support for not only the health of Vermonters, but for the health of our ecosystems, and also for a rational and just energy plan for Vermont. And we say fight back, and we will fight back. I'd like to now introduce Noreen Hession from Energize Vermont.
Hi, I'm Noreen Hession. I'm with Energize Vermont. Energize Vermont joins Vermonters for Clean Environment in objecting to the recent action of the Legislative Committee on Administrative Rules. In 2016, the Vermont legislature voted overwhelmingly to support Act 174. Act 174 promised to strengthen protections for Vermonters who live near wind turbines, wind energy plants. They did this in large part in response to the number of people, a lot of these people who were wearing these ugly green vests. These people came and they sat in hearing rooms, they asked legislators to do their jobs. They said, please regulate the wind industry and please protect Vermonters. There are people who've suffered at the hands of wind industry for years, and they've been coming here to the State House and they've been ignored for years. They've been coming here asking for help. It wasn't until one of our Swanton friends suggested we wear these things that legislators started saying, oh look, they're here again. What exactly is it that they want? So it's citizens in ugly green vests, not well-paid lobbyists who were looking for help who got some attention. Act 174 directed the Public Utility Commission to develop noise rules that would provide stronger protection for Vermonters. The PUC, whose 3 members were appointed by Governor Peter Shumlin, carried out the task diligently and conscientiously. Actually, last week, John Walters said on Vermont This Week that the rule was developed through the lens of the Scott administration, and that's not accurate. All the PUC members who worked on the rule were Shumlin appointees, and Chairman Volt, who's a Shumlin appointee, signed the rule in May before he retired. The PUC developed a rule that relies on noise limits and setbacks to protect Vermonters. Some members of the LCAR are trying to dismantle the PUC's rules by piecemeal in a chaotic policy-making effort that exceeds the committee's authorities and expertise. In doing so, they've misrepresented the intent of the legislature, they've disrespected the PUC, and they've further eroded public confidence in state government. While the wind industry is the primary beneficiary of LCAR's actions, the committee's attacks on the proposed turbine setback rules could open the door for other polluting industries to contest a wide variety of setback-based environmental regulations that have protected Vermonters for decades. The wind industry has become one of our most corrupting influences in Vermont. The industry's poured money into political campaigns, it's subverted Vermont's old line environmental groups, it's engaged in vote-buying schemes in Essex and Windham counties. The industry is destroying what Vermonters hold dear by turning neighbors against neighbors, town against town, rural Vermonter against urban Vermonters, and environmentalist against environmentalist. Wind developers have begun projects without proper permits. They've put turbines turbines hundreds of feet away from where their permitted locations are. They've operated in violation of their permits. They've attacked and mocked neighbors who've been negatively impacted by their turbines and then dared to complain. And now the industry and their lobbyists appear to be directing some LCAR members in an attack upon the PUC. We've heard LCAR members claim that the PUC's rule is the strictest in the country. The committee knows that claim is untrue because it's been shown that other states have stricter rules. Yet some committee members continue to repeat the false claim. We've heard LCAR members say that the PUC's rules will end wind energy development, and that's also not true. In fact, Denmark has the most successful wind energy program in the world, and Denmark has stricter standards for turbine noise rules than the PUC has proposed for Vermont. The wind industry in Vermont wins new enemies with every project that it builds. The opposition to wind projects and the stench of industry corruption is now affecting other types of energy projects. Wind proponents say we can't meet our energy goals without wind. It's more likely that we can't meet our energy goals with a corrupting wind industry that's tainting Vermont's entire energy program. It's the position of Energize Vermont that Vermonters need protection from industrial-scale energy development, and Vermont's wind industry needs reform. The PUC's proposed rule should be the first step in that reform. It's the position of Energize Vermont that Vermont should adopt the PUC's proposed rule.
Thank you. And Stephanie Kaplan, attorney, would like to speak?
Hi, I'm Stephanie Kaplan. I'm an attorney. I actually, just like Ed, used to work for state government and have attended a number of LCAR hearings over the years and have never seen anything like it. That is, I heard about it, I didn't attend it. But after hearing about it, my role as the attorney is I went to the law. And the statute, both the statute and LCAR has its own rules that it's made under its own authority, which just reiterate what the statute says, and those are the 6 reasons that LCAR can object to a rule. And the citation is 3 VSA section 842 and their own rules. And I can read these, or you can go, anybody can look at them themselves, and, well, I will read them, because I don't think, from what I heard, anything that happened that day falls within the reasons they are allowed to object. They can object only if made on the grounds that, 1, the rule is arbitrary, the rule is beyond the authority delegated to the agency, the rule is contrary to the intent of the legislature, the agency did not adhere to the strategy for maximizing public input prescribed by the Interagency Committee on Administrative Rules. 5, the rule is not written in a satisfactory style. They can object to the style. And it's not accompanied by an adequate economic impact statement. And as I said, these are the folks who were there. They can tell you whether any of these criteria were what LCAR was addressing. From what I heard, that wasn't what was going on. They didn't like the rule, they didn't like the substance of it, and they were trying to change it with the industry lobbyists texting them and meeting them outside and doing all kinds of incredibly inappropriate things. Thank you.
Thank you. And this is the document that was filed by the PUC with the Secretary of State's office and LCAR. It shows they did a lot of work. It's a very substantive document. So now we'd be happy to take questions.
Can you, Annette or Ed, isolate for us as specifically and precisely as possible the offending behavior that you saw on display at that meeting? Was it specifically the objection to the setbacks, or were there other specific interactions that you witnessed by members of LCAR to the Public Utility Commission or other people who were testifying that day that give rise to these concerns?
Well, I'll speak to that first and then let Ed answer. I think that it would be inappropriate for us to comment on some of the interactions that we saw without knowing what they were. That's why we filed the public records request. They could have been texting about, can you believe this is 4 hours and we haven't had lunch? They could have been sending notes that had nothing to do with the discussions. But I will speak to something that happened that led up to this.
Before you do that, are you saying that you're objecting specifically to what you believe was electronic communications between members of LCAR and...
No, we're objecting to the actual questioning that went on and the type of questions that were asked in concert with what we all witnessed. But what led up to this was that about a week and a half ago, Renewable Energy Vermont held their annual conference. And they had, as they always do, a workshop on wind. And that workshop on wind was video recorded, and you can go watch it. Bob Farnham is the one who recorded it. It's posted on his Facebook page and on his website, Bob the Green Guy. And at the very end of that wind workshop, which was almost entirely focused on this rule, with RSG's Eddie Duncan presenting, and there was also someone from Vestas and from Goldwind presenting, Eddie Duncan went through much of what he did last week. Senator Mark McDonald was in the room. And he spoke, and you go to the end of the video and you can find, at least 3 minutes of him speaking, saying, I don't think LCAR has heard what we heard in the room today. And he essentially invited RSG to come and present. Now, as chair of LCAR, he didn't contact us and say, we'd like to take some testimony on the technical issues, and we'd like to hear from both sides. He invited the wind industry in. Had I not seen that video, we would not have known what was going to happen. And what do you know? First thing Monday morning on Columbus Day, I looked at the schedule, which had 4 PUC people on it, and there was Eddie Duncan right at the top of it. And over the weekend, we had made arrangements to have Steve Ambrose, who had testified twice already in the workshops, make a trip over from Maine so that at least there was some balance. But the way that that happened was not appropriate. And then what went on with, it just made us wonder, what are the communications between these folks? But I really, as I said, I think it's inappropriate for us to make any allegations or assumptions about the, going out in the hallway, notes passing, texting and all that. We apparently will get whatever those communications are, including the text messages, when we have our records request filled. And Ed, would you like to speak to it at all?
I'm just wondering, look, as to that 4-hour experience that you had there, beyond the objection to the setbacks, what was it that you witnessed that you found so offensive in terms of abrogation of process?
I'll mention 3 examples. And it's an understatement to say Vermont's a small place, and many of us have known each other for a long time. So the 3 examples are, number 1, the comment of Senator Ginny Lyons, in which she was expressing anxiety and wringing her hands and worrying about the substantial cost that would be accrued to a developer to comply with these rules in order to obtain a certificate of public good for the wind turbine projects. This was shocking and offensive to me because I remember Senator Lyons before she came to the legislature. And Senator Lyons was a citizen activist once upon a time in the town of Williston. And she was part of the committee that was opposing the malls that were proposed for Williston at that time. Senator Lyons at that time had no worry about the cost to the developer in going through the permit process. She said the permit process is what we have in Vermont and it should be honored and respected. How the song has changed for Senator Lyons over the years with the coaching of the wind industry. A second example of the comments of Representative Chestnut Tangerman, who I've known for a number of years in my former capacity with the Progressive Party. On October 12th, I heard the representative expressing great concern that under the setback rules, one person would have, he said, veto power over these projects. One person would be able to stop a project. Well, there are many statutory provisions, including zoning, Act 250, and others in Vermont, where even if the impact is unreasonable or undue one person, the permits are not granted. So here's a slippery slope being established by a progressive candidate that by virtue of the fact that the sound standards may not be met in the setback by the developers, now perhaps a permit should not be denied. It used to be an injury to one was an injury to all. I see this as hypocrisy. And I guess the third example I saw was by the chair of LCAR himself, Senator Mark McDonald. Again, I've known Mark McDonald for a long time before he came to these hallowed halls, and he was on the Planning Commission in Williamstown as I administered Act 250. And in that capacity, Mark was always one that was a rigorous applier of standards on behalf of the larger public good. Well, I went to many hearings in the Senate Natural Resources Committee over the years about all the proposed bills to regulate and increase the level of review for wind turbines in Vermont. And it was amazing to me the number of hours that Senator McDonald was never in that room hearing testimony. And yet, Senator McDonald had this epiphany somehow to be able to render all sorts of opinions about the sound impacts wearing his hat as chair of LCAR. Again, I see that as another standard, another example of the hypocrisy which strikes at the transparency of state government. These people are being fed their lines in an effort to monkey wrench a public process. They should honor that process. Those are the three examples I wanted to point out.
And I do have one more that's come to mind. We witnessed a fair amount near the end of the hearing when we were all tired and cranky and really thought, what is going on here? Of Senator Lyons in particular fussing over the 39 dBA standard and was it arbitrary? And on the table there was printed out an email that VPIRG's Sarah Wolf sent on September 25th to LCAR. So this is something that we don't, we have this, it's not anything we need to get through public records requests. And it is it's a 2.5-page document that quibbles with the 39 dBA, and it also quibbles with 42, but in particular 39, but then they say the Commission acknowledges that 45 dBA exterior is fully protective of public health. It's unclear what studies the Commission has reviewed to support 42 daytime. So what this shows is that what we witnessed was, first let's get rid of the setbacks. Now, and then let's get rid of 39 at night. Now remember, we already had a draft rule that was 35 at night with setbacks. That was the right rule. But the wind industry complained, so we got rid of 35, we go to 39. Now they want to get rid of 39, and then they want to get rid of 42. 45 is what they're going for, and what's going to happen at the next LCAR meeting is a continuation of what started, except that they won't have to go out in the hall because they'll have 2 weeks to prepare to make their case that 39 and 42 are arbitrary. That to me was really, watching that, what was going on, and then when I saw this memo, it all made sense.
The setback rule, the PUC offered to walk away from the setback rule as long as the decibel standard was maintained. Their conclusion, I think Margaret said, was that you will achieve our objective if you maintain the 39 dB decibel rule. What do you want to happen next week? What are you urging the PUC to do?
So it's an important point to note that the rule with the setback was by essentially Governor Shumlin's PSB. It was the new chair, Anthony Roisman, who offered to remove the setback. And I believe that he made that offer to get the rule through. And the staff believes that the monitoring and modeling components will still be effective. We do not agree with that, but he made the offer. Now, it is clear that that's not good enough, because if it was, the rule would have, Senator Benning's motion to approve the rest of the rule would have carried. And the reason that what didn't get voted on was because they didn't have the votes to do that. So they're going to come back and they're going to try and whittle away more at the rule. And I think that this very obvious and blatant failure to respect the PUC's process puts the PUC in the position where they should say, here's our rule, it's a package, it's setbacks, we've already given on the sound standard, we're not giving any more, take it or leave it. And if you're going to sue, why give up 39, why give up 42? VPIRG's going to sue no matter what, they've made that clear. So I would hope that the PUC would have some backbone now and retract their offer to remove the setback, because they made it in good faith, it wasn't accepted in a way that moved the rule, and they have total prerogative to do this.
What do you want, or ordinary Vermonters who are sympathetic to you to do between now and next week, what recourse do citizens have with respect to LCAR?
Well, with respect to LCAR, I mean, we didn't engage in a massive lobbying campaign. That's not what we feel is appropriate. We want them to, do their job and approve the rule as presented with the housekeeping that was recommended by the Ledge Council. But in terms of what we want Vermonters to do, we want Vermonters to be aware of how our state government and our legislature is being compromised by moneyed interests, as Emerson Lynn calls them. And these moneyed interests they've really been in control of this state house on the wind industry for so long. I mean, I got involved in the wind issue in April of 2009. In 2010, we had a bill introduced that had both setbacks and sound standards in it, decibel levels. And at the time, the House Natural Resources and Energy Chair, Tony Klein, refused to take it up. Year after year after year, he refused to take it up. And under Governor Shumlin, for 6 years, we were shut out. And I was told by the Speaker of the House, Shap Smith, that nothing was going to get through. I said, well, how are we going to move forward on renewable energy? And he said, we're not. And that was at the opening of the session that led to the green vests and led to the directive of the legislature to develop this rule. So we have been almost tortured by this legislature. And this is not democracy. We want Vermonters to understand that we're not anti-wind, we're not climate change deniers, we are not cave people, all the names we've been called. We are Vermonters who care about each other and who want to make sure that we do things right and that we're not causing harm to people. And so it's so ironic now that what we're hearing is that if LCAR's wind friends don't like the rule, then they'll take it up in the legislature. We never wanted it to go back to the PUC because they had failed. We came to the legislature and said, take it up. They sent us back to the PUC, and now, if the wind industry doesn't like the rule, they're going to send us back to the legislature. And this is not good government. That's the message that we would like Vermonters to understand, is that the wind industry is a very corrosive topic, and I've asked 6 wind developers, please work with us, please do it differently. We have reached out across to our adversaries on so many occasions, and the answer is the hair's on fire, we don't have time to have that conversation, we don't have time to talk about it, and those words come from Senator Bernie Sanders, those words come from Bill McKibben. We have to talk about it. We have got to sit down and look at the issues in a rational way and say, is there a way for wind to work? Because the way it's working now, the wind industry says it's our way or the highway, and we won't talk about it. That's why I say this issue of the decibel levels is so important. The dBA scale is the gold standard for the wind industry because, as was said at the wind workshop at Renewable Energy Vermont, the Vestas man said that the solution for onshore is their 4 megawatt turbine because its generator goes slower, so it comes in at a lower dBA level. Somebody actually asked, well, what do you consider sound? What frequencies? Well, 20 and above, 20 hertz and above. Well, the low frequencies are all a huge problem with this, and so that's why this rule without the low frequencies is very disturbing. So having a rule with no low frequencies, and now Vestas is saying that the answer is 4 megawatt turbines. I went and looked them up. They're 790 feet tall, and Vestas is saying that's our answer because it will result in lower dBA. Does nothing to address that the taller you go, the longer the blades, the louder the low frequencies are.
Well, Senator McDonald said the setback has more to do with aesthetics and the view than it does with sound. Could you live without, if you retain the 39 dB sound standard and scrap the setback? Would you do that?
No. The problem with removing the setback is that the setback, by the way, is inadequate. It's not enough. It wouldn't have helped, for instance, Don and Shirley Nelson. They live further away than 10 times the total height of those turbine blades. However, it is a very good first screen. It takes out the very easily identified problem areas. There's no question, and we gave them the maps, that pretty much everyone within a mile is very seriously impacted. So the setback, as I think, it surprised me that they put it in, but it's a very important part of this. And so to remove it, what happens is, okay, so let's take the three projects we have, Swanton, Irisburg, and Holland. All of them have more homes closer than any other wind projects that we've seen built to date. We've got neighbors 3,300 feet away at Georgia Mountain. At Swanton, we're talking about 2,200 feet away, or even less. And so what's happened in these communities is that they've been turned into communities that are targeted. And the Holland case is going on right now. Swanton is now 2 years into it and creates tremendous uproar for the citizens. People can't make decisions about selling their homes or doing home improvements or anything. And then in Irisburg, same things happened. All of those projects have too many homes too close. And so it would have been a screen that says, either don't do these or work with the community. And the only work with the community we've seen has been in Lowell, and that's been all about the money. It has not been about protecting anybody. So no, the setbacks are important. The Bavarian Constitutional Court upheld through a court process a 10 times total height setback, and in their decision they said that the wind industry does not have a right to just keep going bigger and bigger and bigger. They can do smaller turbines. The ones that go fast around, they don't have the low frequency and infrasound issues. The low frequency noise and the infrasound are clearly what Vermonters are mostly complaining about, and the view is not the issue. I attended a workshop at Harvard Law School in 2011 for wind developers, and we had breakout sessions. There were about 100 of us, and at each breakout session then we reported in, and the first session we were supposed to say, what are the problems? So I'm sitting at the table with Iberdrola and First Wind and all these guys, and we all report out, and the facilitator was shocked. He said, do you realize not one of you mentioned the view?
So if given the 6-2 split at LCAR, if PC comes back and clarifies the language and the setback standard has been withdrawn, what's your recourse?
Well, VPIRG is threatening to sue over the rule no matter what. VCE does not like to litigate. We want to work with people. So if they are not happy with 39 and they come back to the legislature, we can come back to the legislature. I mean, this is obviously not over. There are other opportunities that we have. What I was getting at about the setback is that it creates two things: an incentive to work with the community, and it also provides some initial protections so that you're not turning all these communities into places of total uproar. And so whatever happens with this rule, and it's very clearly deficient, as I mentioned, in numerous ways, there are, in terms of respecting the process, we could petition the PUC to do another rule. We have all, but that's respecting the process. What we're seeing going on here is not respecting the process. If they want to sue with the rule as presented, let them sue. Mike, you have any questions?
Do you have any indication that the wind industry was responsible for getting the setbacks removed from the proposed rules?
They presented, yes, they made a presentation at the last workshop. They also made the same presentation at the first LCAR meeting. They said that if you do this, it'll shut down wind.
The setback wind?
Yeah, and they had maps, and I then testified at the second, I think it was the first or so, I think it was the first one, because they held a workshop where this was presented, so we didn't have a chance to respond to it. So in my testimony at the first LCAR hearing, I presented the maps that showed that the Renewable Energy Vermont maps are dramatically different from the maps that are being used by our regional and town planning commissions to show wind resources. And I've got them here. You can compare the wind industry's maps. In some towns show 0 wind resource, but the regional planning maps show all kinds of wind resources. So the wind industry made a presentation about shutting down wind and what these rules would do based on data that was dramatically different than what our regions are using to develop their own standards.
Or the PUC.
They minimized the wind resource to make their case.
Have you seen any evidence that they were properly influenced? Like it seems like you're saying LCAR perhaps was? by the administrator?
That's why we filed a public records request. And I want to say that,
Have you seen any evidence?
oh, that they were, well, it was developed under Chairman Volz and Governor Shumlin's appointees, and we came to the legislature because they had done a lousy job. There have been dozens and dozens and hundreds of complaints around these wind projects that have never been followed up on. And so this rule development under Chairman Volz was absolutely not ideal. And certainly it was influenced by the consistent mindset we've seen that ignores the problem, but still they developed a rule that we, sort of arguably said, yeah, it does, it's not arbitrary, they've done their job. The big issue in terms of the neighbors, and this gets in the weeds, is that the current standard that we have of 30 dBA interior is more protective than what the rule provides with 39 at 100 feet, based on 3 tests that have been done at a Vermont home that show that the home attenuates 1 to 3 decibels. The PUC, or the LCAR, was asking them the other day, well, you say 9, but it could be higher. So they were claiming that the number was too high or too low. We think it's not low enough. So the other thing that we witnessed with the previous LCAR was a different makeup, was the temporary rule, which clearly says it is to be no less protective than what we have now. They actually weakened the rule. They adopted 45 exterior, 30 interior, but the interior standard was always with windows open in all 4 seasons, and they made it windows closed in the winter and under questioning. The PUC staff member said the reason we did it is because it's something the industry has long wanted. So the interior standard is now gone. If the setbacks are gone, if we have a nighttime decibel level of 39, 100 feet from the house, and the home only attenuates 1 to 3 dBA, you're going to get higher than 30 inside the house.
Thank you all.
Thank you.
Thank you very much for coming. And we will let you know the results of the fulfilled public records request.